Mic check. Hello, hello. Welcome. This is Just Human episode 376. And this episode, we're finally going to catch up on what's going on in the SPLC case and then also in the 2020 election probe that's been happening in Fulton County. There's two special prosecutors or special counsels, but they're not full-fledged special counsels like with an office and all this appropriation of money and all that kind of stuff. It's they've just been empowered by, at the time, AG Bondi to investigate any criminality around the 2020 election. Thomas Albus, who was the U.S. attorney for Eastern District of Missouri, I believe it is. He's the first special counsel that was named, and he's the one who got the search warrants for the raid on Fulton County's record storage facility, that warehouse raid that Tulsi Gabbard showed up to. He's the one who got that search warrant. And then the other special counsel is U.S. Attorney Dan Bishop, who is for the Middle District of North Carolina. He had a grand jury that issued subpoenas for all of the records of employees, contractors, and volunteers who worked the 2020 special election in Fulton County. So I have an update on that case. Actually, it's kind of a resolution unless there's an appeal. The issue of the subpoenas has been decided. So I covered that in a portion of this episode. And then in the next portion, I cover all that's happened with the SPLC case in June and in July. Basically everything since the superseding indictment came out on June 2nd. And there's been some developments in it. There's been a lot of filings, but only a half dozen of them are actually worth our time reading. Most of them are just other lawyers joining in to support the SPLC, who is, of course, an institution on the left, a weaponized institution on the left, and a very rich entity, almost $1 billion in assets and cash on hand. And there's a lot of people on the left coming to their defense. And the issues in that case that are going on is that SPLC is really arguing their defense of what they're doing is not, well, we didn't lie to the bank. We didn't commit wire fraud. We didn't money launder. There is no conspiracy here regarding how we pay our informants. That's not what they're arguing in their filing so far, anyway. They're arguing Trump is mean and bad, Blanche is mean and bad, Stephen Miller is mean and bad, and they're all saying very bad things about us, and they're making the SPLC look bad, and it's prejudicial, and they may have misled the grand jury, and they want access to the grand jury transcripts. They want a show cause hearing because they say a draft version of the superseding indictment was leaked too early to media, and it violated grand jury secrecy rules, and it prejudiced their client because of how stories were written about their client. And motion to dismiss for vindictive prosecution, which those 99 out of 100, if not 900 times out of, I don't know, 999 times. Yeah, it might be 1 in 1,000 of those vindictive prosecution things actually works. So I don't think it's really worth our time to read that filing. Anyway, so I have those updates. And then what I'm going to start out with is a little bit of Russiagate D-Class, which just landed as I was finishing up the other segment. So welcome. I already went through all my coffee, and I had to go and make myself some chai tea. And I'm gonna go over these new Russiagate stuff. Thank you to everybody who commented, sent me messages, bought me coffee, subscribed to my Substack. Everybody who responded to my episode 375. Really appreciate your comments and your messages. Thank you so much, and all your support. Just thank you. Linktree's in the same place it always is, in my profile or in the description of this video or podcast, wherever you're watching or listening. If you go to my Linktree, you'll find all the places to follow my work, all the places to watch my videos, all the different ways you can listen to the podcast, and all the ways that you can support. I really appreciate everybody who supports what I do here. I love doing this work, even if sometimes I'm not fully, fully well in my head. And am depressed. It's not because of work, it's because of other things. And I really love this process of finding documents for you guys and reading them and breaking them down and trying to find the understanding instead of the reacting. So thank you all very much. Let me find, I got playlist on Rumble and YouTube. If you're kind of new here, I do individual videos on Rumble and YouTube, and the cases that I'm following or the issues I'm following, I make playlists for those. And the segments of this episode of the podcast, those will be trimmed and put into videos that go into a playlist. And then there's also a playlist just for the podcast. And on Substack, I put the podcast out. I don't do the individual videos on Substack. I just feel like Substack is not the best form or platform for short form videos, in my opinion, or shorter videos. But it is a good platform for articles and for podcasts. So I upload the podcast on Substack, and that way it's available as both a video and as a audio. And then I also put the podcast on X because, hey, X is the biggest platform as far as people being interested in this kind of stuff, and I'm banned from the other ones. So can't go there. Anyway, now I'm back to thinking about the SPLC case because places I'm banned, they may or may not have had a bit of a hand in that. All right, so we have some D-class from the White House. They say, actually, let me enjoy a sip. Maybe you will enjoy a sip too, real quick before we dive into this. All right, so today the White House released some declassified memos that concerned the Russiagate investigation and specifically the time period of May 2017. And the image they released to it is not the best choice of an image to release to it because this really doesn't have anything, I can't say anything to do with Comey, but that's the wrong face to have here. The FBI secretly opened probe alleging Trump fired Comey because he was a Russian asset. The classified memos show is what this headline says here. And they have a picture of Comey and then a quote from John Solomon, who says the FBI opened a criminal probe specifically targeting Donald Trump in May 2017, even though the Bureau's own evidence overwhelmingly showed at the time that there was no collusion with the Kremlin. And they put Comey's face here, which is sure to make a lot of people mad because so many people on the right hate James Comey, and a good portion of the people on the left also hate James Comey. So bam, you get clicks and views anytime you mention Comey or put his face somewhere. The thing is, and the reason I say it's wrong, is because this investigation they're talking about wasn't created by Comey. It's McCabe. It's McCabe who opened this investigation and authorized it and pushed it. It's McCabe who investigated President Trump. Comey never investigated President Donald Trump. All the reporting I'm seeing, this image from the White House, the news article on Fox News, Axios, The Hill, and anywhere else I scanned, they all focus on Comey and Trump and Rosenstein, but none of them mention McCabe. I'm sure there's probably some article out there that does mention McCabe being the acting FBI director at the time this was opened and being the director who signed off on it. But they leave him out of it. And I think it's the most bizarre thing that he's not targeted here. After Comey's fired, it's McCabe who goes after President Trump. It's McCabe who has the personal animus towards President Trump. It's McCabe whose wife ran for office in Virginia and was supported by Hillary Clinton to the tune of over $1.5 million, I believe, or maybe around $100 million. Comey didn't go after Trump. McCabe did. I mean, I can get why Comey is associated with this story because allegedly Trump fired Comey because the Kremlin wanted him to. Sure, whatever, dude. This is not believable in his face, but of course our understanding of this is a bit skewed. Here's Robert Gouveia, who I like. I like Robert. He wrote Comey Trump attack exposed. I get it, but why is Comey the target over here? You know, what's happening over here in the trending section? I wonder if Comey's trending. No, it doesn't show it. I feel like the trending section is doesn't work as well as it used to, but I don't know. It's always been manipulated. Is Comey trending or is McCabe trending? Neither one is at this time. Todd Blanche is. SCOTUS is. It's news. Let's go to this trending. Nikita's leaving X. Is McCabe anywhere on here? I don't see it. I don't know why my dog is whining, but maybe it's because I keep mentioning McCabe. Other people's dogs whine because you mentioned Comey, but I trained my dogs right. My dogs know who the bad guy is. The bad guy is Andy effing McCabe. All right. So this D-class document, it tells us about an investigation, a secret investigation that has been classified until this time, run by the FBI into Trump being in cahoots with the Russians to fire the FBI director. But we already knew about it. This was declassified on December 11th, 2023. This document right here, this FBI memo. There's an opening of the investigation, and it's a counterintelligence investigation opened May 16, 2017. So just days after Comey was fired, and right before the day before Robert Mueller was appointed. And it tells us at the direction of the Assistant Director of the FBI's Counterintelligence Division, which is Bill Priestap, I believe, following consultation with the Office of the General Counsel, which is James Baker, the FBI is opening redacted based on the articulable factual basis that reasonably indicates that President Donald J. Trump may be or has been wittingly or unwittingly involved in activities for or on behalf of the government of the Russian Federation, which may constitute violations of federal law. That's right. We already knew about this investigation. It was declassified a long time ago. And before this memo was declassified, we already knew that there was an investigation into Trump that was opened right after Comey was fired. What we didn't know back then was the name of the investigation and the general theory of it, basically. Now we know the name of it, Oxford Comma, which, of course, is an allusion, or whatever the word for it is, to Christopher Steele. And the Steele dossier, the fully debunked, absolute trash heap of rumor mongering and fabrication, the Steele dossier. And yes, I agree. The FBI already knew at this time that the Steele dossier was junk. The CIA knew the Steele dossier was junk. It's all by this time at this period of this opening, there was awareness that there wasn't a factual basis to open this, but there was a factual basis to investigate Russian interference in the election and Russian influence operations. And merging those two things together, plus all the rumors and other things going around, they came up with this. All right, so let's look at the real memo. And I don't know, I'm at, shout out to the Clinton Foundation timeline.com, clintonfoundationtimeline.com, where they have so many, if not all, the Russiagate related stuff. Very, very useful website. And thankfully they have this there as well. I want to view this. It says full screen here. I don't know. That's not going to work well for you guys. I could have just downloaded this thing. That doesn't work well either. Maybe I can. This is a very pro show. Don't make fun of it. It's a very pro show. Very, very pro. This is actually new. Do I need to go download it from the website? Because then I'm going to have to open up a reader and all that. Okay, let me just zoom in here and we're going to make it work. We're going to make it work. I'm just going to zoom in a lot. Okay. Oxford Comma. All right. I can't highlight this, but I want to point something out to you guys. Oxford is misspelled. and comma. The O and comma does not appear to be the same shape as the O in Oxford, but I don't know if that's really true or if it's just the typeset, like it was just an error with the type. I don't know, but for the printer, but it does look, the O over here looks more squeezed like a zero would than this one. And when I look at other O's, there's one right there in foreign. See, there's some zeros down here, but they're bold. See, all the other O's, like this one, they're more round. This one matches that one up there in counterintelligence. But the O and comma looks a little bit more squeezed, like it's the number 0. It looks to match more the zeros here and the 0 right there in 2017. So I don't know this for sure, but it is hypothesized, theorized, whatever, that one of the ways that people in government can hide things from FOIA is to misspell various things and to put different letters in there or numbers in there in place of letters. And then that way, when someone types in a search and does a FOIA request, I want a FOIA request for anything called Oxford Comma or any document in the government that mentions Oxford Comma, it wouldn't return because it's misspelled and there's a 0 in place of an O. So by doing that, you hide things from FOIA without actually hiding them. I don't fully buy into that. And the reason I don't fully buy into that is because I think it's it's clever. I'm not saying it's never been done. But there's other explanations for why things sometimes come up with letters that don't match, like Comey and Corny. So there's a famous example of when you did a search, you would find some documents mentioning Comey. But if you did a search for Corny, Corney, you find a lot more. And it's because when you use this typeset they use, I can't remember what it's called right now. When you put an R and an N next to each other, it almost looks like an M. Comey. But one of the explanations for why that happens is because documents that are typed or printed out, when they become a PDF, they get scanned, and then the scanner ends up misrepresenting the letters and numbers. There's a name for it when it does this. I can't remember what it is right now. So I'm not shutting down that theory that they misspell things in order to hide them from FOIA. I'm not shutting that down. I'm just saying there's another explanation for it. But I think here I lean towards believing it. When it comes to this specific example, I lean towards believing it was misspelled on purpose in order to hide it from FOIA. That way, in case an investigation called Oxford Comma was ever leaked to media, was ever rumored, if someone put in a FOIA request for it, they wouldn't get a return on it because Oxford was misspelled. Here, I'm not saying it is the case here. I'm saying in this instance, I lean towards believing it, but in other instances, I lean away from believing it. Maybe at some point we'll find out an explanation for why they spelled Oxford this way, and it'll make sense, and we'll be like, oh, okay, that's why. But yeah, all right. Anyway, so it starts off at the same thing we read before. The difference is that, actually, let me compare them. Let me grab this. So this is redacted, drafted by case ID. This is redacted. You see, this is still redacted, drafted by redacted. Case ID number is partially redacted. And then the name of the case, Oxford Comma, is that redaction has now been lifted. And then right here, I believe that says top, does that say secret or top secret? And then no foreign right there. Those are now redacted, which doesn't make any sense because you can read them just fine right here. All right, right here under initiated, full investigation. So they were hiding the fact that this was a full investigation that was initiated on that date. It's not a preliminary investigation. It was a full one, which a full one gets a lot more resources and authorizations. And then right here, FBI is opening redacted. Full investigation is what was under that redaction. All right, here's the rest of it. The goal of the investigation is to determine if President Trump is or was directed by, controlled by, and or coordinated activities with the Russian Federation in a manner constituting a threat to the national security of the United States and or violation of federal criminal statutes. In addition, this investigation will also seek to determine whether President Trump and others yet to be named obstructed and or conspired to obstruct any associated FBI investigation. The FBI is predicating the investigation on predetermined criteria set forth by the Crossfire Hurricane investigative team based on an assessment of reliable lead information received during the course of the investigation. In May 2016, a named member of the Trump campaign, of the Trump campaign team, indicated he was knowledgeable that the Russians made a suggestion to the Trump team that they, the Russians, could assist the Trump campaign with an anonymous release of information during the campaign, damaging to the Clinton campaign. Now, who was that? I believe who they're talking about is Roger Stone. One of the most vile, snake-like creatures to ever enter the DC political swamp. Roger Stone. I do not have one nice thing to say about him, and I have a million bad things to say about him because he is a bad, bad person. And he met with Julian Assange. He talked with Julian Assange team. He was trying to get the stuff that Julian Assange had, and I think that's where this is coming from. I think this is very much Roger Stone. So in other words, Roger Stone running his mouth and associating with some very bad people, including people connected to the Russians like Julian Assange, ended up causing Trump and his campaign to get investigated. In other words, there was a basis to investigate the members of the Trump campaign for Russia collusion. We're not supposed to believe that. Oh, if you support Trump, you're not supposed to believe that there's any such thing as Russia collusion or Russian interference or any of that stuff. It's all a lie. Sorry, it's not. Russia did seek to interfere with and influence the 2016 election. They sought to influence both sides of it. They sought to muddle up and confuse and delegitimize the election. They believed Hillary would win, but they believed they could damage Hillary on her way to victory, and then they would have some damaging info on her kept in reserve for after she won, which they could use as leverage against her. You don't have to believe me on that. It's all in the Durham report. It's all in the classified memos that have to do with the intel that was intercepted by the Dutch and Cozy Bear and all that stuff, and the GRU and communications because the Dutch hacked them and got their internal chats. We already know all this. We already know about the investigative lead, that there was the Russians were behind the attack on the hack on the DNC. But because we're in hyper political times, and the media has done a disservice on both sides, the media lies to their viewers in order to skew the conversation and the narratives. People get pushed to extremes. But the evidence is what the evidence is. There's no evidence that Trump colluded with the Russians. There is evidence that the Russians interfered with and influenced the 2016 election. There is evidence that Julian Assange received the hack materials from the GRU and released them. And there is evidence that Roger Stone was seeking to work with Julian Assange on releasing that information. So when you know all those things, you start to see how something like this, Oxford Comma, could come about. Now, I'm not absolving anybody of corruption. I'm not absolving any of us, but certainly not Andy McCabe. But there's a fuller picture to be painted here than what legacy media, right-wing media, left-wing media is willing to paint. In addition, this investigation will also seek to determine whether President Trump and others yet to be named obstructed and or conspired to obstruct any associated FBI investigation. The FBI that's also something we already knew. We already knew that there was an obstruction investigation later on by Mueller to investigate whether or not Trump obstructed the Mueller special counsel, which of course he did not. The FBI is predicating the investigation on predetermined criteria set forth by Crossfire Hurricane. Wait, I already read that. All right, according to U.S. intelligence community information, Russian intelligence gained access to the DNC networks as early as July 2015 and maintained access through June 2016. Circa March 2016, Russian intelligence also gained email access to senior Democratic Party officials and political figures. The U.S. intelligence community assesses with high confidence, beginning in June 2016, Russian intelligence services used DCleaks.com and WikiLeaks to publicly release the material obtained through the aforementioned cyber operations. Yes, they did. This is all correct. According to multiple open source reports, the Trump campaign intervened during the course of the GOP Platform Committee discussion on Ukraine in the run-up to the 18th through 22nd July 2016 RNC in Cleveland. Allegedly, through this intervention, the Trump campaign members were able to amend the GOP platform language on U.S. support for Ukraine away from, quote, the provision of lethal defensive weapons, end quote, to a more anodyne call for, quote, appropriate assistance. The FBI assesses this platform change would be favorable to Russian interest following their annexation of Crimea. Immediately after the RNC, Trump and his then campaign manager, Paul Manafort, another very crooked person with very close ties to some bad Russians, publicly denied any involvement in softening the language on Ukraine. However, following the 2016 presidential election and inauguration, Trump's foreign policy advisor during the campaign, Jeff Gordon, told CNN that he pushed the platform change to align with Trump's views. Gordon said he, quote, advocated for the GOP platform to include language against arming Ukrainians against pro-Russian rebels in line with Trump's views, expressed at a March 2016 national security meeting for the campaign at the unfinished Trump Hotel. Gordon's post-inauguration comments to CNN are supported through FBI investigation. According to FBI information, Gordon advised members of the Trump campaign foreign policy team on 14th July 2016 that they, meaning the campaign, had defeated red line amendments like providing lethal assistance to Ukraine. Pause. Perhaps I'm not fully appreciating the significance of this language change. But I think the platform and literature like this that is put forth by campaigns as part of a convention, lead up to an election, all these things, they matter, but do they matter this much? Does it really indicate, is it a strong indicator of collusion to take language in a platform, which is just a political pledge, from someone who's running for office but does not have office yet? This says specifically the provision of lethal defensive weapons. This is a very specific thing, and it involves lethal weapons. Okay, changing that to appropriate assistance. Personally, I think this is kind of practical, reasonable to make this change. It's probably well advised to change that language to appropriate assistance, because you then couch your promise on further information in determining what is appropriate to provide. You're still pledging assistance. The reason I bring this up is that this is just a political promise. And once Trump is elected, he gets way more information on the situation. And what if he gets in and realizes that providing providing weaponry to them directly is going to cause a lot more problems politically, or even, just foreign policy wise, than some other form of assistance, such as intel sharing or financial assistance or whatever. All I'm saying is that this is not, they're making this out to be a huge thing when all it is a pledge, a political pledge that can change at any moment. I just don't, I don't think it's significant. Sure, it's a thing that should be noted maybe, but it's just not super significant. All right, open source information indicates that President Trump has had a long-standing business and real estate ties in Russia. This is true. And former Soviet states. This is true. Stemming from the late 1980s. In 2008, President Trump's son claimed that Russians made up a disproportionate cross-section of many of President Trump's assets. Open source information also indicates that President Trump has had business ties in the United States and Russia with named Russian oligarchs. This is true. As part of this investigation, the FBI is also seeking to determine whether President Trump and others yet to be named obstructed and/or conspired to obstruct any associated FBI investigation. An effort to impede the FBI's investigation into Russian efforts to influence 2016 election could have a negative impact on the United States' ability to fully understand our foreign adversary, protect national security, and the FBI's ability to enforce criminal law. Starting on 28th January 2017 and continuing through at least April 2017, President Trump had multiple conversations during one-on-one personal meetings and telephone calls with FBI Director James Comey. This is true. Comey wrote those things down, didn't he? In which he repeatedly A, sought Comey's personal loyalty, B, asked Comey to politicize or publicize the fact that the president was not the subject of an FBI investigation, C, asked Comey to do what he could to resolve the investigations and lift what the president viewed as a cloud over his presidency. In addition, President Trump expressed his hope that Comey not further pursue the investigation of former U.S. National Security Advisor Michael Flynn. The rationale provided by President Trump for the 9th May 2017 termination of Comey has changed over time. President Trump's 9th May 2017 letter to Comey stated that he was being terminated at the recommendation of the Attorney General and the Deputy Attorney General of the United States. A White House press release issued the same evening repeated that President Trump acted based on the clear recommendations of both the Deputy Attorney General Rod Rosenstein and Attorney General Jeff Sessions. On the evening of 9th May 2017, White House spokesman further added the termination had nothing to do with Russia. In a televised interview on 11th May 2017, so 2 days later, the rationale changed when President Trump stated that he made the decision well prior to the recommendation of DOJ, and that I was going to fire regardless of the recommendation. And in fact, when I decided to just do it, I said to myself, this Russia thing with Trump and Russia is a made-up story. It's an excuse by the Democrats for having lost an election that they should have won. This alternative explanation can be reasonably read to imply that the FBI's counterintelligence investigation was a factor in President Trump's decision to terminate Comey. But Trump wasn't under investigation. He wasn't under investigation. So see, their conclusion here of reading this is that an alternative explanation can be reasonably read to imply that the FBI's counterintelligence investigation, Crossfire Hurricane, was a factor in President Trump's decision to terminate Comey, even though it was Comey who told Trump, "You're not under investigation." Pretty weak. As the captioned subject was a candidate of a domestic political campaign and is currently serving in national political office, the FBI has categorized this investigation as a sensitive investigative matter and considered the factors set forth in. Based on facts and circumstances provided to date, the FBI believes that opening this investigation is the least intrusive method to address the serious national security risk posed by the activities alleged. This is weak. Now, if this was just for an investigation into Roger Stone, I would applaud it. But this is very weak, and it's what you get from McCabe, because McCabe is the one with the personal vendetta. All right, next one. This is a document dated the same date, Oxford, Comma, 16th May 2017 at 12:30 p.m., acting FBI Director Andrew McCabe made notification in person to Deputy Attorney General Rod Rosenstein of the FBI's opening of a captioned matter. That's also, this isn't really weird. It says right here, FBI, Andrew McCabe did this, and then he let Rosenstein know. I've seen reporting going on blaming Rosenstein for authorizing this when it's McCabe who did. Anyway. People get the wrong targets assigned to them. All right. This is the closing communication from almost 2 years later, April 8th, 2019, David Archie. And it says, on or about July 31st, 2016, the FBI opened a full investigation, Crossfire Hurricane, based on information provided by London, which is from Christopher Steele, to determine whether individuals associated with the Trump campaign were witting of and or coordinating activities with the government of Russia. Some were. On or about May 16, 2017, using predetermined criteria established by Crossfire Hurricane, the FBI opened a full investigation based on the articulable factual basis that reasonably indicated that President Donald J. Trump may be or had been, wittingly or unwittingly, involved in activities for or on behalf of the government of the Russian Federation, which may have constituted violations of criminal law. The investigation also sought to determine whether President Trump and others yet to be named obstructed or conspired to obstruct any associated FBI investigation. On May 17th, the very next day, the acting attorney general appointed special counsel and authorized him to conduct the investigation confirmed by then FBI Director James Comey in testimony on March 20th, 2017. So that's the separate investigation, including any links or coordination between the Russian government and Trump campaign. Any matters that arose or may arise directly from the investigation. Okay, you understand what happened here? After appointing the special counsel, responsibility for the closed investigation was transferred to FBI personnel assisting the special counsel. McCabe lost his investigation into Trump 24 hours later. That is why in past videos I've said for one day, Trump was under investigation by the FBI. For one day, McCabe was able to go after Trump. The appointment of Mueller took that away from McCabe. And what did Mueller say in his report? What did he say in testimony? Trump was not the target of his investigation. Media on the right tell you otherwise. Politicians on the right tell you otherwise. Media on the left tell you otherwise, and politicians on the left tell you otherwise. The documents don't. The order appointing the special counsel gave the special counsel's office jurisdiction to investigate matters that arose from FBI's Russia investigation, including whether the president had obstructed justice in connection with Russia-related investigations. The special counsel's jurisdiction also covered potentially obstructive acts related to the special counsel's investigation itself. Special counsel's investigation included the use of a variety of investigative techniques, blah, blah, blah. Appropriate resources and personnel were expended, blah, blah, blah. Conclusion, special counsel provide the attorney general with a confidential report explaining his prosecutions and declination decisions, blah, blah, blah. And that's it. So I am excited about a little bit of Russia D-class. I'm totally messing up my scrolling over here. I'm excited to get this D-class, learn that this was called Oxford Comma, and I get a little bit of a kick out of that name. But once again, who did the documents point to? The documents point to McCabe. The trail of malfeasance, of corruption in the FBI keeps leading back to Andrew McCabe over and over and over again. And these other bogeymen that keep getting assigned to us by politicians and media, Comey, Rosenstein, even to an extent Strzok and Lisa Page, man, it's it's just it's misdirection. Now, I'm not saying that all of them are doing it knowing that it's misdirection. I think it's just become reflexive now. And somehow McCabe has been just forgotten in all this. But he's the guy. Let me see if I can just play this right here to close this segment out. Let me see. I think don't think you guys got the audio of this. Let's see. No, it's not coming through for you guys. Something changed my audio settings. This is a very pro show. It's a very, very pro show.
And you had concerns about Donald Trump's ties to Russia, but that you were investigating him. What can you tell us about that?
That's right. So, you know, an important part of that very dramatic step of initiating investigation, certainly getting that recommendation from my team, considering it very closely, approving it for the reasons that I've detailed. And we had observable facts that indicated that a threat to national security may exist and a crime may have been committed.
You were specific. We are investigating the President of the United States because we are concerned that there may be something amiss regarding his relationship with Russia.
I was perfectly clear of that.
On that point.
Yeah.
Perfectly clear of that point.
The basis upon which we made that decision was perfectly clear. We were in possession of facts that made it abundantly clear that we had an articulable basis to believe that that threat might exist. And under those circumstances, the FBI is obligated to open a case. If we don't open a case because the subject happens to be the President of the United States, we're not doing our job.
I happen to agree with that they have to. If they've developed evidence of a crime, it's their job to investigate it regardless of who that person is or what position they hold. But they didn't have that. They had the evidence to investigate Stone and Flynn and some others. Some of those things actually developed into prosecutions that should have occurred. Some of them didn't. But the politicization of it and their own animus towards Trump and their loyalty to the left and to Clinton, and their desire to, I don't know about desire. There's another, with McCabe specifically, there's another factor that goes back to his leaking to Devlin Barrett through Lisa Page 6 months before this, which I've covered on other episodes. McCabe knew that Comey knew. McCabe had lied to Comey about the leaks to the Washington Post, and McCabe was trying to find his position and put off. He was hoping he wouldn't be discovered as the leaker, that he hadn't leaked through Lisa Page. This was before Horowitz got involved, right? So McCabe, when Comey is fired, it takes McCabe 5 days to open an investigation into Trump. I think he got that thing. I think it was a directive of his to the counterintelligence team, put together something that will allow me to open up a full investigation into Trump specifically. And what we just read is what they put together. And it is so weak. But it was McCabe's way of politicizing the FBI as much as he possibly could against the president. If there's anyone to be charged here, it's McCabe. But everybody's going to get distracted, even the White House, distracted by Comey. This, what do you do? What do you do? Anyway, glad to have the D class. In a little bit of a way, glad to retread some of these things, but also disheartened and just I don't know what the emotion is. Just watching the same old false narratives and misdirections play out, and people walking away with the wrong understanding of, or at least a skewed understanding of what went down with Russiagate. But understanding is greater than reacting, but understanding doesn't bring a lot of clicks and views. So, all right, that's it. That's it for that segment. All right, so I'm back with an update in United States v. Southern Poverty Law Center. It's been a while since I covered anything to do with this case. I think the last time we talked about it was very early June 2nd, when the superseding indictment was filed. Immediately after that superseding indictment was filed, the defense, SPLC, filed a motion for an order to show cause because they said that DOJ had messed up and they'd sent a different version of the superseding indictment to media, and that version had gone out in media before the SPLC had even been given a copy of the superseding indictment, and that this had harmed their client, and that this was in violation of the federal rules of grand jury secrecy, because this, of course, an indictment comes from a grand jury, and there were multiple versions of this, and the version that's on the docket doesn't match the version that the media got from DOJ's Office of Public Affairs, or whatever it's called. And I went over that at the very end of the last video I did covering the superseding indictment. Now, since then, and basically the entire time this case has been alive, but especially since then, all throughout the summer, there's been all these motions to appear, motion for leave to appear from all these out-of-district attorneys who are filing to make briefs or file briefs here as friend of the court or whatever, on behalf of these third-party groups that have an interest or an affinity for the SPLC, such as the Society for the Rule of Law, a very Orwellian name, Democracy Project, right here, Protect Democracy Project. There's been a bunch of them. So it gets kind of like frustrating scrolling and trying to filter this docket, because you have all these outside groups that are filing in here and all these different attorneys from other districts. And most of them are granted by the court. And there's so many of these where like, okay, where the judge is saying, okay, yeah, you can file, or no, you can't because you didn't certify that you're in good standing with whatever court, all these things. I'm not going to bother going through these friend of the court briefs or these briefs in support of the SPLC from these third-party groups, because I just don't think it's worth my time or your time. I see them anytime there's a really political case. I see these come up. They came up a lot in the Trump cases. And occasionally there's one that is worth going through and reading, but I'm not going to do it unless it's incorporated into a motion. Like I remember with Trump's, the docs case, there was, in both the docs case and the election interference case they were brought by Special Counsel Jack Smith. There was a brief by Ed Meese that ended up being very relevant and impactful in the case, and led to his, or at least partially is responsible for him being the docs case being dismissed by Judge Cannon, where she said that no, Jack Smith was not lawfully appointed, and that his brief was incorporated into the filings of Trump's team. So if SPLC incorporates these filings into their motions, or if the judge takes note of one of them and says this one, like I don't remember who was in it might have been in the election interference case, it seems like, but it might have been a docs case. I remember a judge saying this brief, basically mentioning it in an order, and then saying, I want both parties to file briefings on this third party in their filing. So the judge thought it was compelling and wanted both parties to make filings about it. And that, if that happens here, then I'll cover these. Otherwise, I'm just going to stick to the stuff that really matters. I'm also going to skip over in this case the motion to dismiss the indictment because of vindictive prosecution. Just like in the Trump cases, again, we saw these motions to dismiss for vindictive prosecution. Saw them in the Comey case, and again in the latest Comey case with the seashells. There's motions to dismiss for vindictive prosecution, and those things so rarely succeed And they're really just an occasion where like they're just one party is listing all of the times they were offended by something the president said, whether it's President Trump or in the Trump special counsel cases, it was Biden. Um, and it's not enough. It's not enough that the president said mean things about your defendant or your client who's now a defendant. That's not enough. So they just very rarely succeed. And I remember the one of the motions to dismiss for vindictive prosecution that was filed by Trump's team. It sounded very much like Trump himself wrote it. And I read it then, and it was entertaining, but it didn't ultimately amount to anything consequential in the case, right? So, okay, so there's an order here about the show cause where the judge took up the show cause motion and said, I want both parties to file responses and briefs on this. DOJ needs to file a response by June 15th and all these things. DOJ did file a response by June 15th. I think they did it on June 15th right here. And they said, look, the draft version of the superseding indictment and the version that we filed here in this court are substantially the exact same. They say the exact same thing. There's no significant difference between them. It's just a matter of some of the wording was altered, and they're correct about that. They also put in this filing that we filed the grand jury return superseding indictment. We filed it in the court or like at 2 p.m. that day, and then hours later, a draft version of it that had been given over to the Office of Public Affairs or whatever it's called, in order for them to prepare for media questions about the new indictment once it became unsealed in the docket. That draft version ended up going out to media from DOJ's Office of Public Affairs or Office of Public Relations, whatever it's called. I always forget the name of it, the official name of it. And that was a mistake. They admit to the mistake and just say, yeah, that was a mistake. They had a draft version of it that was only meant for them to be briefed and to be caught up on the superseding indictment in preparation for it being unsealed. And they ended up sending that draft version to media when they should have sent the official one that was on this docket, stamped, and is the final version of it. But there was no harm. Yes, we made a mistake, but no harm resulted from that mistake, and we did not violate federal rules of grand jury secrecy or anything like that. So the other thing that's going on around this time, well, here, I should say this. In addition to the superseding indictment, there's a couple motions or filings that are kind of hanging or are pending in this case at this moment in middle of June here. It's motions to dismiss for vindictive prosecution, which I just talked about, the show cause filing, because they want the judge so SPLC wants the judge to hold DOJ in contempt for violating grand jury secrecy and for putting out this document to the media that wasn't the real superseding indictment, or wasn't the final version, I should say. And a motion for disclosure of grand jury proceedings. This is actually the most important thing going on, is this motion to disclose the transcript of grand jury proceedings. SPLC has been seeking this since very early on in this case because they argue that DOJ may have misrepresented the purpose, the function of the informant network that SPLC had been running, that the grand jury was not informed of how SPLC used these informants to gather intel on these extremist groups and then turn that information over to DOJ or other law enforcement, and that prosecutions had resulted or had been aided by the information gathered by these informants. That's true. It's just not true in every instance. And DOJ is not charging the Southern Poverty Law Center for informant activity or behavior or payments to informants that resulted in some sort of prosecution. That's not they're not being charged for that. They're not being charged for running an informant network. They're being charged for lying to banks. They're being charged for bank fraud and wire fraud. Yes, SPLC used their informant network at times in certain instances to gather information that was later turned over to law enforcement, but not every time. And the informants that are referenced in all of the filings by DOJ in this case are ones that did not lead to some sort of prosecution. There wasn't some sort of dismantling operation of the extremist group going on with these specific informants. Instead, what was going on is SPLC was funding the extremist organization and the individuals in it. So the judge has an order on this matter for disclosure of grand jury transcripts or grand jury proceedings, which is a very high bar. It's a very high bar to get that disclosure. And they did not meet it. And the judge denied their request for the return of grand jury transcripts. SPLC is charged with wire fraud, false statements to a federally insured bank, and conspiracy to commit and conceal money laundering. Now, what about those charges would be undone if the informants that were being paid had gathered information that was turned over to DOJ or not? Nothing. It doesn't matter whatsoever. It does not matter. If all of the informants mentioned in this had gathered intel that was later turned over to law enforcement, it wouldn't change the fact that the SPLC committed wire fraud, false statements, or conspiracy to commit money laundering. It wouldn't change anything about those charges. So she denies their motion for grand jury transcripts. Okay. Now I gotta scan some more between these things. Status conference, hearings, motion to dismiss for a vindictive. We're gonna skip that. Here's SPLC's response to the show cause. DOJ came in and said, hey, we didn't cause any harm, right? Well, here's what SPLC says in response. DOJ admits that a mistake was made and that it was clearly wrong document. The wrong document was sent to the media, while ignoring that this is the second instance of the prosecution caring more about playing to the press than to the court or to the jury. Pause. I 100% agree with this criticism of DOJ. This DOJ has made numerous blunders because of their tendency to do exactly that. Play to the media rather than to the court or to a jury. That's how we got both of the Comey cases, which one is dismissed and another, the Seashell case will soon be dismissed and will go down as one of the most boneheaded, ridiculous, absurd cases ever brought. The Epstein fiasco, blunder, quagmire. It turned into a quagmire politically. That is all screwed up because of playing to the press, and then people in Congress figuring out, oh, we can get on one side of this issue, and we can try and we'll make ourselves seem like we're all we're pro victim advocacy, and we're pro transparency, and we hate pedophiles and all these things. But really it was just a political stunt that ended up causing way more harm than good. So yeah, I completely agree with this criticism of this DOJ. Still doesn't change anything about this show cause in this instance of a rough draft of the indictment going out to media. Okay, it attempts to distance itself from its own actions using creative phraseology, like media members erroneously received the draft document. Okay, lawyers, this is what makes you a good lawyer, right? This could be part of what is the job of a lawyer? Creative phraseology. Right. As if it was not DOJ that had erroneously sent the file. Yeah, DOJ messed up. They said so. It asked the court to ignore the text of Rule 60, which governs grand jury secrecy, and does not address the main issue here, which is, why is DOJ engaged in a media campaign about this case at all, let alone one seemingly orchestrated by the highest levels of the Justice Department? Okay. restating their second point there with that. Okay, I'm going to scan some more. Another amicus. More attorneys getting admitted. Attorney getting admitted here. Same thing there. Same thing there. Another one. So many. Another one. And another one. And another one. All these lawyers getting in on this case. Remember, SPLC is a near $1 billion entity. They've been around for a long time, and they are I think of what the right description is. They're an institution on the left. They're an institution on the radical left. And they're a weapon for the radical left. Protect democracy. Okay, this is response to quarter by USA. It doesn't describe exactly what it is. Sorry. Raised by the SPLC. This has to do with Stephen Miller and things Stephen Miller said. What filing is this in? Is this in response to the show cause? Hold up. What is 74? Vindictive prosecution. Okay. Because Stephen Miller, White House official, has said mean things about the SPLC, this case should be dismissed because it's vindictive. Blah, 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 blah. Consent to file under seal. This is from July 2nd, so a month after the superseding indictment. SPLC requests that the court permit it to file under seal a short supplement to its motion to show cause. As grounds for this request, the SPLC states that good cause exists to file this pleading under seal, including the fact that the filing contains numerous references to sensitive matters, including the identity of individuals, which could create safety and security issues. No party would be prejudiced by the filing of this pleading under seal. So they're not saying for only the judge, they're just saying under seal where only the counsels and the judge can see it, both sides. The judge granted it, same day. Okay. And then 2 weeks later, there was a motion for oral argument on the pending motions by the SPLC. SPLC has filed 2 motions, which remain pending before this court. Motion to dismiss for vindictive prosecution, and a motion to show cause regarding the superseding indictment and it going to the wrong version of it, going to the media, the wrong draft. During the status conference, the court expressed a willingness to consider holding oral argument on the outstanding motions if requested, and the SPLC is making that request. The judge denied it. Before the court is defendant's motion for oral argument. It is ordered defendant's motion for oral argument is denied without prejudice. Should the court later determine that oral argument is appropriate, a separate order will issue. Interesting. She said, nah, we don't need to hold oral arguments on it. I've got your filings. But I may change my mind. Order as to SPLC. All right, here's the show cause order from the judge. And this is, I need to check the dates. So on the 20th, she denied. On the 15th, they filed for oral argument. 5 days later, she said no. The next day, she makes an order on the show cause saying, in consideration of issues warranting confidentiality, privacy, and sensitivity with the public right to access documents, the parties shall brief whether the entire supplement or any portion thereof should remain under seal. So remember, they had that earlier under seal filing. Parties should address whether redaction or certain information would sufficiently address the sensitive matters. And then this continues into August 4th, which was yesterday as of this recording. So this is going to continue through August. They're dealing with this show cause thing. If she's given that serious attention, she may end up writing a sternly worded order against DOJ. I don't know. I don't really think much is going to come from this show cause thing because there was no harm. Clerical error. It's on DOJ's side, and I mean, I just don't think it rises to the level, but we'll see. Motion for leave to file a redacted pleading, another one. This one filed on July 30th. By order dated July 21st, court directed parties to brief the question of whether the SPLC's motion to show cause should remain under seal, or their supplemental briefing to the motion to show cause should be under seal. The court asked the parties to address whether, in light of issues warranting confidentiality, privacy, and sensitivity with the right to public access documents, blah, 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 we would like to please file our response under seal. In order to fully respond, SPLC believes it's necessary to redact significant portions of its response so as not to compound the concerns which prompted its original filing under seal. And then the judge granted in part, it looks like. No, this is a motion for pretrial scheduling order, granted in part. Okay. Pretrial motions are due in August. Blah. All right. Now that this is all about the scheduling. Okay. And then the final one, which SPLC just filed. The court directed the parties to brief the question of whether the SPLC's previously supplied or previously filed supplement to the motion to show cause regarding the superseding indictment should remain under seal. The court asked the parties to address whether, in light of issues warranting confidentiality, privacy, and sensitivity with the public's right to access documents, redaction of certain information would sufficiently address the sensitive matters, upon which the unopposed motion for leave to file pleading under seal was based. Then we have a paragraph redacted. The supplement was rooted not only in the negative effect on the SPLC's right to a fair trial and the apparent violation of Federal Rules of Criminal Procedures 6E, but also the concern that redacted. Redaction is insufficient to address the concerns which motivated the supplement. While the Supreme Court has explained that there exists a general right to inspect and copy public records and documents, including judicial records and documents, it also recognized that this is common law right to inspect and copy judicial records is not absolute. Blah, blah. It's up to the court's discretion on what should be granted. So they bring up Trump in this and the Jack Smith cases, and they bring up that multiple courts in this circuit have recently considered the potential impact of disclosure of a named individual's identity might have in the context of a sealing request. In the search warrant that was issued to Trump back in 2022 in the Southern District of Florida, the court balanced the government's asserted compelling need for sealing against the public's interest in disclosure and noted that one factor that weighed in favor of sealing was the significant likelihood that unsealing the affidavit would harm legitimate privacy interest by directly disclosing the identity of the affiant, as well as providing evidence that could be used to identify witnesses. As discussed above, these disclosures could then impede the ongoing investigation through obstruction of justice and witness intimidation or retaliation. I can smell cooking going on upstairs. As I'm reading this, all of a sudden I'm smelling food. Sorry, this is a side note. Okay, special counsel sought these things and the August search warrant of Trump's property at Mar-a-Lago, applying the analogous good cause standard contained in Federal Rules of Criminal Procedure 16. The court granted the motion to redact witness names from the motion and directed special counsel to file under seal an index containing the name of each potential government witness and a corresponding pseudonym or anonymization for the use in the redactions of defendants. The court also found good cause to redact limited portions of the Jinx material that could directly identify potential witnesses. Jinx material is stuff that comes from the FBI's internal documents. It allowed redactions on the grounds of doing so is supported by the same witness safety rationale that had been deemed in this order to justify redacting witness identities. And then we have an entire page redacted. And then that's it. I'm struggling to conceive any idea as to why there's a bunch of sensitive things or names and whatnot that need to be redacted or sealed that has to do with this show cause. Unless they have information that the draft of the superseding indictment made its way out into the media well before DOJ said it did. Otherwise, I think this is kind of odd. Let me go back to this other motion they had before they made the filing under seal. We read this part. They got a problem with the no harm, no foul approach of DOJ as it regards this instance. They still reiterate that Blanche lied to media about SPLC, which the judge has already told them no, he didn't lie. The government's response is also quick to note that the SPLC makes no allegation that the actual U.S. Attorney's Office prosecutors leading this case were involved in the mistake that was made with the draft indictment. As if that makes this permissible, they minimize it as a regrettable action. Without this being the time for the court to address these improper actions, appear to be orchestrated or directed by high-ranking officials at Maine Justice. All told, the government concedes that its conduct was an error and that clearly the wrong document was sent to media, while asserting no violation of grand jury secrecy and no prejudice to SPLC. This position misses Rule 60's core protection for disclosures that tend to reveal secret aspects of the grand jury's work, including strategy and charging direction. It also wants to leave unanswered questions that squarely implicate the court's supervisory authority. Why, in the first place, any advanced, fully editable Microsoft Word draft indictment was provided to the media prior to public docketing? Why changes were made between the draft and returned versions? Who authorized the executed the dissemination? And specifically, any involvement of the acting attorney general, meaning Todd Blanche. What internal controls failed? Exactly what was sent to whom? And whether any other grand jury material was shared, and why the official indictment was not shared with counsel at the same time the media received a draft. Court should grant a motion. I didn't pick up on any clues right there as to what they would need to seal. The government claims the superseding indictment was publicly disclosed as soon as it was docketed, while simultaneously acknowledging that it was not publicly available at such time. Whether or not the superseding indictment was under seal when DOJ disseminated a draft pleading to the press does not change the fact that the existence of a superseding indictment was unknown and unknowable to the public and to the SPLC at the time of DOJ's dissemination, to say nothing of the U.S. Attorney's Office's last-minute edits the morning before the presentation. Those acknowledgments raise precisely the kind of Rule 60 concerns. Man, I'm having a really hard time seeing how SPLC was harmed by a draft of an indictment that says the same thing the official final version of the indictment says, with only very minor changes to the paragraphs. to make it basically just read better. I don't see how it prejudiced SPLC. The government claims no harm was done by its mistaken disclosure and error because the indictment was accepted and docketed more than 3.5 hours before the wrong version was sent to media. The draft was near identical, and any pace or unavailability is unknown and legally irrelevant. The government maintains the correct version was publicly disclosable as soon as it was docketed, and asserts unknown reasons for why it was not on Pacer when the media received the draft. But public disclosability on paper is not the same as actual availability to the public and press. Here, the undisputed first narrative to the media came from DOJ's release of the wrong pre-decisional draft, not from the clerk's official record. The government admits media members erroneously received the draft document from the DOJ Public Affairs Office, and at least one media member alerted defense counsel. Maybe that's who they want to protect. In the sealed filings, they want to protect that a media member contacted SPLCs. That's it. That's it. Now we know. The SPLC, which is an institution of the left, was alerted by a friend of theirs in mainstream media to this draft version they had received from DOJ PAO, the Public Affairs Office. And SPLC realized that media got a draft version of it before the version that was on the docket had been unsealed. And they think they have caught Blanche, and they're trying to paint this picture. All of their filings so far, all of SPLC's filings in this case so far have sought to undermine the credibility of this DOJ and its officials. All of them. All of their filings are seeking to not defend. The only way they've defended their clients so far, which of course we haven't seen all of the defenses they've constructed. So I'm aware that I'm observing this before their time for defending their client has completely concluded, right? So there's going to be more defenses that they could bring up. But so far, in the first, 4, 5, 6, 7, almost 5 months of this case, so about 150 days of this case, the first 150 days of this case, SPLC has not defended themselves by saying, we didn't lie. We didn't commit wire fraud. We didn't commit the charged offenses. Here's what actually happened. It's a misunderstanding of accounting or something. Or the bank's messed up. Or none of that. All their filings that I can recall right now are focused on Stephen Miller, Trump, Blanche. They didn't go about this the right way. They're running a media campaign to damage our client, to damage the SPLC's reputation. That's what they're going for. And they want to protect this person in the media from being disclosed to the other counsel and publicly. There might be more than that, but that's at least one thing that they would be like, yeah, we need this. We want this sealed. Where the government prematurely curates the initial storyline with a draft, the resulting one-sided narrative, confusion to the media and public, and potential taint are manifest, particularly when the defense cannot responsibly correct the record without amplifying the off-record disclosure. Okay. Moreover, the fact is that after DOJ released the draft that evening, at least 2 media stories appeared online, only exacerbating that confusion and taint and prejudicial effect of DOJ's premature dissemination. And it does not matter that, in the government's view, the changes may have been minor grammatical changes or non-substantive. I think it very much does matter. So I'm going to say right now, I don't know this judge. First case I've ever covered in front of the judge here in this case. So I don't know what she's like or her politics or anything. I did look at some other cases she'd been involved in, but nothing jumped out to me where I could say, okay, this is the type of judge, or I don't know what way she's going to lean. But immediately to me, I'm thinking, okay, The storyline that was initially created off the draft version media got. How does that storyline different than a storyline they would have written based on the final version of the superseding indictment that appeared in the docket? Because there's no substantial difference between the draft and the final version. They bring the same charges, they tell the same facts, they allege the same things. It's just a difference in wording and phrasing. But isn't the stories the media wrote about the superseding indictment, they're the same stories saying the same thing, whether it's based on the draft or the final version. So how has SPLC been prejudiced here? What is the taint? What is the confusion that has happened? Are the articles more one-sided in the narrative they convey because they based it on the draft version versus the final version? If the draft version had been like very much different than the version the grand jury approved and got filed, okay, I could see how there's prejudice there. But it's not. They're not different. SPLC argues that whether the differences had no effect or resulted in no prejudice to the SPLC is just convenient characterization. No, I think it's very much the substantial difference. It's not quite, I understand that like no harm, no foul isn't always appropriate, but when the document we're talking about is so similar, then you really need to characterize the harm that actually happened because they based their stories on the draft version and not the final one. They say instead, what is revealed by this conduct is that it is the second instance in this case in which the Justice Department has put the court of public opinion ahead of a court of law. That's the real angle here, guys. That's the real angle. That's what they're really trying to get across. Don't blame them. I don't blame them for that. The government's own narrative establishes that the violation has occurred. Dissemination to the media of a draft charging document prepared for grand jury presentation, differences between the draft and returned versions, regardless of the number of paragraphs, the timing of the release that precluded contemporaneous public access to the official charging document, and the involvement of the DOJ U.S. Attorney's Office personnel subject to Rule 60. The government really admits all this. So, blah, blah, blah. I shouldn't scan it, so let me be more careful. Government argues SPLC cannot pass the first hurdle because the mistaken disclosure was of a document never before a grand jury. But that formalism misreads the rule. The test is substantive. Whether the disclosure would tend to reveal matters occurring before the grand jury is the rule. But simply, the government speaks out of both sides of its mouth. On one hand, it argues that the disseminated draft was never before the grand jury. Thus, it doesn't go beyond Rule 6C's reach, while simultaneously arguing that a near identical version was presented to the grand jury, so no harm resulted to the defendant here. At a minimum, sworn declarations and documents from both U.S. Attorney's Office and DOJ are needed to determine the nexus of what's going on here. A nexus. There's a nexus here, really. The court should also disregard irrelevant insinuations. The SPLC has, their filings are insinuations. Insinuations that this DOJ and Mueller and Trump and Blanche are all have a personal vendetta against the SPLC, which a lot of us who have been affected by the SPLC's extremism do feel some kind of way about the SPLC, don't we? Okay. The issues at stake here are the government's dissemination, authorization, controls, and the impact on grand jury secrecy and trial fairness, not the SPLC's constitutionally protected right to speak publicly. Man, I don't think the SPLC wins here, but they're not I don't they may not win on this show cause, but they're trying to just push their own narrative of crooked DOJ being mean to their client, which is not that different from filings we saw back when Biden was in office and Republicans made filings saying Biden DOJ is being mean. I know I'm really dumbing it down there, but yeah, I'm not too far off in that. Okay, so that, at least I don't think so. All right, that catches us up with the SPLC's case. So we're waiting on the judge to rule on a motion to dismiss for vindictive prosecution. We're waiting for the judge to rule on this show cause for the dissemination of the draft version of the superseding indictment. And the grand jury disclosure, I don't think, oh, where'd it go? The judge already denied their motion for disclosure of transcript of the grand jury proceedings, but I believe it's denied without prejudice, right? I don't see it where it says there. It just says denied. I think it's without prejudice anyway. Yeah. So she denied their motion because they failed to meet their burden that would allow for grand jury materials to be disclosed. I would not be surprised if we see a motion for that grand jury disclosure again. And part of it's going to reference what's at issue in this show cause, because they're going to try and show this DOJ keeps making mistakes. And since they made this mistake with dissemination of a draft version, it's not that far-fetched to believe they made a mistake in front of the grand jury originally, because essentially they've already made a mistake in front of the grand jury in a way because they violated grand jury procedures. See what I'm saying? So I would not be surprised if DOJ if SPLC keeps picking at that, trying to get some disclosure from the grand jury proceeding. All of this is just meant, like I said earlier, all of this is meant to undermine the credibility of DOJ, the prosecutors, Blanche, the White House. It's all meant to do that. SPLC is a weapon of the extreme left, and they are functioning as a weapon here in this case, which is all about wire fraud, bank fraud, and conspiracy to commit money laundering. And instead, they're using it as a tool to do damage to DOJ. They are a weapon. So, all right, that's your update in United States v. SPLC. See you in the next one. All right, so earlier this year, there was a raid in Fulton County on a warehouse that stored all of the election records from Fulton County for the 2020 election, and perhaps other elections. I don't really know, but I know at least there were something like 600 boxes of records that the FBI took out of that storage facility pursuant to a search warrant, multiple search warrants, actually. And among those things that they took out were ballots, cover sheets, envelopes, ticker tapes, all sorts of things. And it amounted to some 600 boxes. They hauled it off in 18-wheeler trucks. Remember that Tulsi Gabbard was on site for it. One of the deputy directors of the FBI was there. Members of the National Security Council were either, they weren't on site for it, if I recall correctly, but they were in town for it and traveled with Tulsi Gabbard, who did make an appearance at it. There were some media shots of it, and all of us got very excited about it. And people on the left and the right got excited about it because something was happening. Of course, their view on it was a little different. Some were excited for different reasons, and some were excited for, because they liked it. Some were excited because they didn't like it. And those raids happened pursuant to search warrants, like I said, and those search warrants were obtained by United States Attorney Thomas C. Alvis, who is the U.S. Attorney for the Eastern District of Missouri. And we would find out after the raid sometime that Thomas C. Alvis had been empowered by then Attorney General Pam Bondi to investigate crimes related to the 2020 election. And he could do that anywhere in the country, and he chose to start, at least as far as we know, start with Fulton County. Now, after that happened, after he obtained those records, a fight happened over those records where Fulton County didn't want DOJ to have access to them and be able to, parse all those materials. And they filed a Rule 41G motion, which is for return of property. That showed up in this case. Pitts v. United States is where that matter was hashed out. And in the last video I did on this subject, I believe, I went through the judge's order where he decided, no, actually the DOJ can access these records, and Fulton County, you will not get these records back. The search warrants were correct. And this judgment came out on May 7th. I read this entire order. Actually, it's not that one. It's this right here, maybe. One of these. I think it's this. Yeah, it was that one. So I read that entire order and went through what the judge said, because the judge did a great job giving background on everything that happened with the search warrant and the raid, and did a fantastic job recapping the entire situation, added a lot of clarity to it, and took away some of the intensity of the politics around it. So that ended that case. Pitts v. United States, that's over. DOJ is now and has been since May going through those 600 boxes of records looking for any evidence of criminality. And that's, a big deal. I agree with Joe Biden. It's a big deal. And a lot of us thought it would be a much bigger deal than so far it's turned out to be. So far, we haven't had some breaking story of something they found. At best, I think the most, what the indicators are is that they're looking for crimes where things weren't preserved. There was the judge's order detailed some indicators that maybe Fulton County didn't follow the law in preserving all the records in the ways that they were supposed to. And so that would be a chargeable offense that could arise out of the raid in Fulton County. It's not expected that there's going to be charges for anything that occurred in 2020. The statute of limitations on that has run. Any conceivable charge that they would bring for actions related to 2020, the clock is already, it's over. The clock's run out on that. But as far as preservation of records from 2020, the clock has not run out on those. So conceivably charges could be brought, and there is reason to believe that that's what Thomas Alvis is looking at. Now, around the same time that was going down, the court battle over who could access, whether or not DOJ could access those records, another U.S. attorney was empowered to look at the 2020 election. And that U.S. attorney is for the Middle District of North Carolina, James Daniel Bishop, or Dan Bishop is what he's usually referred to as. And he ran a grand jury out of North Carolina that sought records for, oops, I double loaded that. Sought records for Fulton County's election workers and volunteers. They wanted access to everything. Everybody, all the personal information of everybody who worked that election, where they worked, what their job duties were, all of their contact information, employment dates or volunteer dates, all of those things. And I thought I had, here it is, right there. This is what that was seeking. Rosters of all of their staff, individuals who reviewed the mail-in ballots, were assigned to the voter panels, the mobile voting locations, those who picked up ballots or transported them, et cetera, et cetera, et cetera. And since Fulton County is a county of some million plus people, and I think it's the largest county in Georgia, that's a lot of people. We're talking about thousands of people that they're asking these records for. Now, Thomas Alvis, he had a grand jury also, but he impaneled that grand jury within the same district in Georgia. And that's how he got the search warrant for the facility that housed the 2020 election records. But Dan Bishop ran his grand jury in North Carolina, and they're seeking records from Georgia. So that's kind of odd. It's not illegal to do that, but it is kind of odd that he's running a grand jury in a different state instead of running one in Georgia. And after these subpoenas were sent out, he got subpoenas for these records. And after they were sent out, Georgia said, no, we're not, Fulton County, I should say, said, no, we're not going to give you all this personally identifying information. This is a overly broad subpoena. It asks for a bunch of stuff that really you shouldn't have. There's not a basis for you to acquire these things. There's no way that you're going to be able to charge a crime for something that happened in 2020. And we're filing this, they filed a motion to quash those subpoenas, which would mean that the court would not enforce those subpoenas, and Fulton County wouldn't have to turn over anything. That court battle started, I think, in May, if I remember right. I want to scroll back here because I think those subpoenas came out, early May. And I think the subpoenas might have been mailed to them end of April, if I'm recalling correctly. May 4th, anyway, they filed this motion to quash. And in July, the judge made a ruling on it. And that's the ruling I'm going to go over next, or in this video. He denied DOJ. He granted the motion to quash. And so these subpoenas will not be enforced. And Dan Bishop will not get all of these employee and volunteer records related to the 2020 election in Fulton County. And just like with the judge's order in the Rule 41 case, the 600 boxes related to the raid, just like the order that he put out in this case that I found so clarifying and informative, just a great ruling. The ruling here that doesn't go the way that I personally would want things to go also is clarifying and is well reasoned and it just seems like a good order to me. So I'm going to go over this order and I'm going to allow the judge to explain why he denied these subpoenas for these records. It makes a lot of sense. And one of the values in going over things like this, and the reason I do these episodes and the reason I go over these court docs, is because one, I love documents, and two, because when we seek to understand what is happening, rather than just allowing ourselves to react to it and kind of shoot from the hip, just let emotions lead us around, when we instead try and understand, things just make more sense, and we don't let our emotions take control of us, and instead we rely on logic, we rely on our rational side of our brain, right? So documents really help us do that. And that's what I like to do here. If you're interested in this video and more videos like it, you can go to my link tree, which is in the description. And there you'll find all the places to follow, all the places to watch, listen, and all the different ways to support. I'm recording this as a video that I'm going to release on YouTube and Rumble, and it's going to go in the playlist that I have for these types of things. This case, I think I just labeled it like 2020 election probe is the playlist. Yeah, Fulton County 2020 election probe. This video will go in there, but this video will also be part of my longer podcast episodes where I give more commentary and more thoughts and talk about my dogs and kids and all sorts of other stuff. And I'll attach this video to those. Okay, so let's go to this order. Hope you have your coffee ready. It's 28 pages. It is a pretty quick read, even though it's 28 pages. There's a couple sections where we can skip. I don't know. I read it earlier, and I don't know if it's because of the font. I think it might be because of the font and the spacing. It actually is a shorter order than the 28 pages at first would lead you to believe. Okay, so this judge, I've already forgotten his name at the beginning of the video. The last one was Booley or Boulay. This one is William Ray. That's it. William Ray II. Okay. He says this matter is before the court on petitioners Fulton County. The petitioners are Fulton County, and they're seeking to quash the grand jury subpoena that was brought about by Dan Bishop as part of 2020 election probe. The breadth of the grand jury subpoena is staggering. It seeks the name, position, function, residential and email addresses, and personal telephone numbers of all individuals who reviewed mail in ballots, were assigned to the voter review panel or board, assigned to any mobile voting location, were involved in the transferring of results or transportation of ballot stock or media, worked in or for the Fulton County Board of Registration and Elections generally, worked or volunteered on election day to review or tabulate ballots, worked or volunteered in the risk limiting audit, worked or volunteered for the recount, and or served as precinct managers and assistant managers for the November 2020 general election in Fulton County. The Fulton County Board of Registration and Elections, which hereinafter will be referred to as just Fulton County, in objecting to the subpoena, points out that the Department of Justice is seeking personal identifying information on what would amount to thousands of employees and volunteers who participated in election day activities, the counting of votes, and any audit or recount of votes. Of note is that Fulton County is the most populous county in the state of Georgia per the 2020 census, so almost 1.1 million people, and one of the largest in land area with approximately 527 square miles. Thus, there is little doubt that Fulton County employs and uses the services of large numbers of people to conduct its elections. Why is the DOJ seeking this information? Well, it argues that it is engaged in legitimate law enforcement activities. Against that claim is the fact that it has long been the view of the current president of the United States, both before and after he was elected in the 2024 general election, that he was denied re-election to a second consecutive term in 2020 due to election fraud. Particularly, he has alleged fraud in states that he won during the 2016 election, but lost in 2020, which includes Georgia. It was alleged both then and now that the genesis of his defeat in Georgia came from supposed fraud at the hands of election officials and others in Fulton County, which provided the final margin of votes in Georgia that decided the 2020 election. Thus, perhaps it makes sense that the DOJ, now unquestionably under the current president's control, is seeking to identify individuals who might possess information or opinions in support of his claim that the 2020 election was not legitimate. And in so doing, or in doing so, the DOJ is using the subpoena power of the grand jury. Footnote: to be clear, no evidence has been presented to the court that the actual grand jury in the Northern District of Georgia seeks this information, as opposed to the out-of-district prosecutors who the DOJ has appointed to lead this inquiry, who have served this subpoena in the name of the grand jury. And by this, the grand jury in Northern Georgia is the one that got the search warrants for the raid. This, again, the subpoenas came from North Carolina. Both prosecutors that we know of who are conducting the election probe, Albus and Bishop, are both out of district U.S. attorneys. But it's not super extraordinary that an out of district U.S. attorney would involve themselves in getting evidence in a different district. That happens. What is weird is to impanel a grand jury in a completely different district seeking information from this one, another one, right? The subpoena or the search warrant for the raid is just a stronger grand jury request because it comes from in district. It should be noted, however, that while the grand jury is an independent entity in many respects, it operates under the auspices of the district court. It is the district court that summons citizens to serve on the grand jury. It is the district court that selects the individuals to serve on the grand jury. It is the district court that administers the oath of office to the selected members of the grand jury. And it is the district court that receives the work product of the grand jury, namely the indictments of individuals who are alleged to have committed prosecutable crimes. It is true that the grand jury works with the DOJ and the applicable United States attorney to investigate alleged criminal actions, but that does not give the DOJ the right to use the grand jury to do whatever the DOJ wants. The grand jury and the tools, i.e. the subpoenas, that it uses are tethered to its authority and the fulfillment of its authorized mission. So, is there anything wrong with the DOJ using the grand jury to subpoena these records from Fulton County? In this court's view, yes. these records, even if they led to the DOJ finding individuals who worked for Fulton County in 2020 election, who support the theory that the 2020 election was not fair, would not lead to information that could be used to charge anyone with anything, at least not any viable charge. And he tosses that in there, like, this DOJ has unfortunately developed themselves a record of bringing charges in high profile cases against some high profile people, and those charges were not viable and were thrown out. We've seen it happen with Comey. We're about to see it once with the leaks investigation, and that's a whole circus, which I covered extensively. We're about to see it happen again with Comey in the seashell case, the 8647 case, which is one of, if not the most ridiculous cases I have ever seen in my entire life. And I haven't made a video about it because I just lose the ability to speak with how absurd that case is. And there's been some filings in it recently that make me want to cover it because the filings they speak to how absurd that case is. And I know it's going to be dismissed. Everybody knows it's going to be dismissed. Everybody knows it's an exercise in just silliness, to be very, very kind about it. But there's also been another example where this DOJ has done some boneheaded stuff, such as charging that former Olympian with damaging the reflecting pool. And there's not enough evidence to bring the charge in the first place. And Jeanine Pirro, the U.S. Attorney for D.C., just dismissed that case. And Trump and Secretary Burgum, I think it is, are upset with her for doing so and all these things. But, this DOJ, that's just a couple of examples. This DOJ has made some really bad blunders. And it doesn't seem it's not beyond this DOJ, unfortunately. I'm really sad to say these things. And frustrated. I could totally see this DOJ bringing charges against people who worked in the 2020 election in Fulton County that they know are not viable charges. But they also know that when those charges get thrown out or the case is dismissed or whatever, they can just say, "Grr, crooked judge in Georgia wouldn't let us hold people accountable." It's a very, very unfortunate, and there's some stronger words I want to use for it. Anyway, back to this. That is because the statute of limitations for any possible crime arising from the 2020 election has long expired, as the DOJ must have brought such a case, if it could, no later than late 2025 or the early weeks of 2026. Footnote: had the DOJ moved expeditiously to seek this information after the current president returned to office on January 20th, 2024, and within the applicable period of limitations, this court's analysis may well have been different. So the judge is saying this DOJ, if they think there's some crime in 2020 election in Fulton County that they want to prosecute people for, they should have been on this from the first week they got sworn in. And, maybe they missed that window because of the holdups with getting Blanche confirmed and Cash confirmed and all of those things. I tend to think it's because there really wasn't any evidence that they could base an investigation on. Yeah, that's what I think. I think they were looking and begging for information that could lead them to open up a case, but they didn't have anything that was, use that word again, viable. They didn't have anything that would lead to a viable investigation. That would actually lead to charges. And so they didn't move until either they got some people in that were willing to do it anyway, or just Kurt Olson and the information that was presented to Albus led them to believe, okay, there is something there when it comes to preservation of records that's required by law. So we can at least go after that and see if we develop anything else along the way. There's a word or a phrase that is used to describe those types, that type of behavior, and it's fishing expedition. And that is what this seems to be, and that is what this judge is going to label it as. Now, we all know, and I'm sure some of my listeners have already said, well, if there's a conspiracy, then the statute of limitations gets toned out. There's no statute of limitations on conspiracy, or there's no statute of limitations on being a traitor or something like that. All right, but we don't have evidence of that. We don't have evidence to support a conspiracy charge, and we don't have evidence to support that there's traitors involved here, or anything that would allow us to say, okay, the statute of limitations hasn't run on this, or there is no statute of limitations on it. Maybe that comes about, but right now we don't have it. And since we don't have it, the charges that would be possible, that are conceivable, all have statute of limitations that have expired. All right, the 2020 election occurred on November 3rd, 2020. Audits and recounts occurred in the 2 to 3 weeks immediately thereafter. The electors of each state making up the Electoral College met to cast their vote for president on December 14th, 2020, and the Congress of the United States met to count the certified votes of the Electoral College on January 6, 2021, although the process was not completed until January 7th, 2021, due to well-chronicled events. Thus, an investigation of alleged criminal conduct of anyone that may have led to the certification of the 2020 election in Georgia would not be a legitimate use of the grand jury and its subpoena power, and that no valid indictment could issue from said grand jury to the expiration of the applicable statute of limitations. I want you guys to imagine something. Say these things go forward, say the subpoena had actually been enforced. They get all this personal information of these Fulton County workers and volunteers. And let's say they bring some charge. I don't know what it would be. Let's not go big and grand. Let's not say a conspiracy charge that shows somebody colluded with whatever and stole the election. Let's do something much smaller. Okay. Let's say that they mishandled ballots let's say they mishandled flash drives that contained the results of the machines, and those results ended up not being in the final calculus for 2020. Let's say they mishandled those USB drives. Let's say a person driving a truck was supposed to collect those drives and turn them in to the Fulton County Board of Elections, and then they would be added to the final tabulation of votes for 2020. Let's say that the person who was supposed to do that was their job, they decided not to do it. Let's say that person had an animus against Republicans, and those results were from a high Republican district, and that person knew that those results were going to all be very favorable to Republicans, which means it would have added a bunch of votes to Trump. And that person said, you know what, screw it. And they threw those things in a trash can. Let's say there's evidence of that there was like a handful of flash drives that contained results from high Republican precincts or whatever got tossed in the trash. Okay. How is it going to look and how is it going to work that a grand jury in North Carolina issues an indictment for someone who committed acts 6 years ago in Georgia related to activity that was authorized, contracted, paid for by Fulton County? It doesn't make sense to do that. It doesn't make sense for the state of Virginia to investigate crimes that happened in Colorado and then bring an indictment in Virginia against someone in Colorado who committed all of their acts happened in Colorado pursuant to activity that was authorized by the Colorado Secretary of State. That's this, that commercial, that Geico commercial. This is not how things work. This is not how anything works. This is not how it works. And it makes me wonder, why did Bishop not just impanel a grand jury in Georgia? I think that's a really good question. All right. DOJ argues that it has a legitimate interest in investigating potential criminal actions in the years that followed the 2020 election, including an alleged failure on the part of Fulton County to preserve its ballot images from 2020 for the time required by law. Now, there's something legitimate. Such alleged failure to preserve records arguably would not be barred by the statute of limitations. Footnote. The DOJ also alleges that a certain number of the actual 2020 ballots that it seized pursuant to a search warrant look suspicious. Again, that search warrant is within district. It's a Georgia district, Northern District of, I think it's the Northern District of Georgia grand jury impaneled in that district by that district that got that search warrant, modified the search warrant on the day of the raid because they found stuff during the raid. They were like, actually, we need to get that too. We didn't know that was here. So that all makes sense. However, even if such allegations prove true, of which this court offers no opinion, the fact remains that the focus of the subpoena is on what happened or did not happen during the 2020 election and the weeks immediately thereafter, not what may or may not have happened in the years that followed after the election was long over and certified. Thus, acting under its authority and indeed its responsibility pursuant to Rule 17C2 of the Federal Rules of Criminal Procedure, the court grants Fulton County's motion to quash. In these hyper-political times in which we currently live, there are sure to be some who disagree with this decision because they believe the allegations of fraud in the 2020 election and believe that light should be brought to those claims. But a couple points are in order. First, nothing prevents a continued inquiry into those allegations by those who believe such claims, such as Congress and perhaps even the DOJ. It is just that the power of the grand jury, which exists to investigate potential crimes and to bring viable indictments thereof, cannot be used as their tool to do so. Second, and relatedly, that this result is fitting is clear if one considers the alternative. Otherwise, anyone in power, perhaps the next administration of a different party, could use the grand jury process similarly to subpoena personnel or personal information of citizens, perhaps that of their political opponents, with no legitimate law enforcement purpose. The information sought herein, names, addresses, phone numbers, emails, is private and sensitive. So much so that should a private company fail to protect such information from electronic thieves, such company would most likely be sued in a data breach class action lawsuit. Thus, everyone, whether you support the president or you do not, or whether you believe the 2020 election was fair or believe that it was not, should be concerned about the DOJ's ability to utilize the power of the grand jury to appropriate your private information without a legitimate purpose. In this court's view, the DOJ does not possess a need to enforce the subpoena greater than the burden of disclosure on Fulton County, and as such, the court will not enforce it. Now, background section here, again, it goes over April 17th was the date of the subpoenas. And if I remember correctly, they got back to them and said, hey, yeah, we might comply with that. And then they switched and said, no, we're fighting it, which isn't surprising. So here are all the things that they wanted. On May 4th, Fulton County filed its motion to quash. Fulton County asked the court to quash the subpoena because its claimed one, that the DOJ issued the subpoenas for an improper purpose. 2, the subpoena is overbroad and untethered to any reasonable need. 3, the subpoena cannot yield evidence related to a criminal prosecution. 4, that the subpoena burdens the First Amendment rights of election workers. And 5, that the subpoena unreasonably interferes with Georgia's ability to conduct elections. The DOJ filed a cross motion to enforce the grand jury subpoena and a response to the motion. The DOJ argues that the subpoena is proper and completely orthodox. The court held a hearing on May 19th. During the hearing, Fulton County supported its argument with additional law and facts. Thus, the court ordered supplemental briefing. Also at the hearing, DOJ gave the court an affidavit that it claimed supported the grand jury's investigation and need for the subpoenaed information. The DOJ also filed a motion for in-camera review. In that motion, the DOJ requests that the court review both the affidavit and the related briefing in camera. Fulton County opposes that request. The DOJ references a related but different case also in the Northern District of Georgia, and that's the Pitts v. United States return of property case that we already talked about. On January 28th, the magistrate judge signed a warrant which authorized the seizure of over 600 boxes of election records from Fulton County. As part of the search warrant application, an FBI agent provided an affidavit to demonstrate probable cause. After the DOJ executed the search warrant on February 5th, 2026, Fulton County, along with others, filed a Rule 41 motion seeking the return of those records. March 27th, United States District Judge Booley held an evidentiary hearing on that Rule 41 motion. Judge Booley ended up denying that motion on May 6, 2026. In that order, Judge Booley found that Fulton County did not satisfy its burden of showing that the government callously disregarded Fulton County's rights through the execution of the search warrant. At the same time, Judge Booley noted that the events leading up to the Rule 41G motion were unprecedented, that the affidavit proffered to obtain the warrant was defective in some respects, that the affidavit's inclusion of certain statements was troubling, and that Fulton County had correctly identified some of the affidavit's features as problematic. I'm going to skip this section. That's some really nerdy stuff. All right, discussion. Fulton County argues that the court should quash the subpoena since its claims that the subpoena is the DOJ's latest effort to target and harass the president's political enemies. This time, election officials, poll workers, and volunteers in Fulton County who Trump continues to disparage as he perpetuates his false claim that they stole the 2020 election. The DOJ refutes this claim and contends that Fulton County, by opposing the subpoena, attempts to undermine the grand jury's very purpose by obstructing the next steps in the investigative process. Under Rule 17c2, in determining whether to quash a subpoena, courts must assess if a subpoena is unreasonable or oppressive. Therefore, the court will weigh the government's investigatory need for the personal information of election workers against the competing burden that Fulton County will suffer in compliance. Skipped right to the court derives this standard. They're going to use a standard from Justice Stevens, which is what is reasonable in this context. So the court derives this standard from Justice Stevenson's concurrence in R Enterprises Incorporated. In its briefing, the DOJ devoted many pages to explaining to the court that concurrences are not binding precedent, and or that a majority opinion is binding precedent. To be clear, the court understands that it is not bound by this concurrence, or any concurrence, except in certain circumstances. But neither must the court disregard such reasoning when a concurrence addresses an issue before the court. This is especially true where there is scant binding authority which defines reasonableness. R Enterprises Incorporated undoubtedly remains the controlling precedent, but presented a different factual dispute. As Justice Stevens observed, the majority opinion may not have provided adequate guidance to the district court regarding reasonableness. Therefore, the court finds Justice Stevens' additional reasoning persuasive when examining reasonableness. Justice Stevens stated that a movement can satisfy the initial hurdle and show some valid objection to compliance by illustrating that, quote, the volume and location of the requested materials, the mere cost in terms of time, money, and effort of responding to a dragnet subpoena, or a movement can show that compliance with the subpoena would intrude significantly on the movement's privacy interest or call for disclosure of trade secrets or other confidential information. And guys, that is exactly what's happening here. DOJ, through Bishop's grand jury subpoena for these records, is seeking an extraordinary volume of materials, and it's going to cost a lot of time and money to get all those things together, and it's definitely part of a dragnet subpoena, and that compliance with it would intrude on the privacy rights and at least their interest of all of the involved parties that they're seeking this information from. The DOJ claims that, quote, the list of employees and workers involved in the 2020 Fulton County election is needed to further investigate potential crimes associated with the 2020 election. Fulton County combats this claim by arguing that it is burdened by the compliance because the subpoena is untethered to any valid prosecutorial need, and its sweeping demand for sensitive personal information as thousands of election officials and volunteers would chill the participation of election workers and impair Fulton County's ability to administer its elections. I can understand that. I think that's probably true to an extent, but what really stands out to me is that the subpoena is not connected to some sort of investigatory need, such as we've developed probable cause, or we've developed evidence that people working in this location at this time on these dates involved with these activities may have witnessed or participated in some criminal act. And so we need their contact information, and we need to identify these individuals so we can continue investigating that possible criminal activity. It needs to be much more narrow because it is so broad. Well, it's too broad. It's just way too broad. If it was connected to some sort of very specific investigatory lead, it would be much more narrow. So, for reasons explained here and below, the court agrees with Fulton County that in pursuing the subpoenas, the DOJ is engaged in an arbitrary fishing expedition, such that the subpoena is unreasonable and must be quashed. The federal grand jury serves two primary roles, sometimes referred to as the sword and shield functions. The grand jury does have broad subpoena power, which gives it the authority to compel the testimony of witnesses and the production of documents and other things, thereby assisting the prosecutor in the investigation of crimes. That is the sword function. Then, after the evidence is gathered, the grand jurors vote on whether the prosecutor has enough evidence to justify charging someone with a crime. In this capacity, it can act as a shield for the accused against unsupported accusations. The primary purpose of any grand jury is to determine whether a crime has been committed and whether criminal proceedings should be instituted against any person. Thus, the grand jury's broad investigatory power should not override its ultimate purpose, to help the prosecutor indict valid criminal charges. Importantly, the Supreme Court has made clear that applicable statute of limitations is usually considered the primary guarantee against bringing overly stale criminal charges. It is true that a subpoena is not objectionable merely because it seeks documents beyond the period of statute of limitations. However, when a subpoena seeks information that is unlikely to result in prosecutable offense because the applicable statute of limitations is expired, the court finds that the DOJ's need for that information is diminished compared to circumstances in which the statute of limitations remains open and prosecution is still possible. As Fulton County lays out in its briefing, the applicable 5-year statute of limitations has run on any alleged crime related to the 2020 election. Since Congress certified the election results at 3:44 a.m. the morning of January 7th, 2021, the 5-year statute of limitations on any purported crime related to the 2020 election ran, at the latest, on Wednesday, January 7th, 2026, which was 6 months ago. Under 18 U.S.C. 3282, a non-capital offense has a 5-year statute of limitations. That statute of limitations applies to offenses under Section 20511 and Section 20701, both are which these are statutes that have been quoted in their documents that they're investigating crimes related under those statutes. 18 U.S.C. 371 is conspiracy to defraud the government. 18 U.S.C. 594 is voter intimidation. 18 U.S.C. 610 is coercion of political activity. 18 U.S.C. 1001 is false representations to a federal government. 18 U.S.C. 1512 is tampering with a witness, victim, or informant. And thus, investigation into these alleged offenses is now stale. These are non-capital offenses, and it's run on all of these. The statute of limitations is run on all of them, without us showing that the subpoena information will result in a prosecutable crime. The court finds the DOJ's need for the subpoenaed information to be questionable at best. Surely the DOJ could articulate a need for almost any evidence. However, that is not the legal standard. Instead, that low need for the information does not outweigh the burden on Fulton County. The DOJ has made various arguments to revive the statute of limitations for potential wrongdoing related to the 2020 election, but the court remains unconvinced by those arguments. Next part, the DOJ is not entitled to indefinitely extend the statute of limitations to usurp established limitations on crimes. Okay, where was this footnote at? Right here. Let me read this footnote. The DOJ places great reliance on the relevance standard in our enterprises. The DOJ essentially suggests in its briefing that a subpoena cannot be quashed if the subpoena bears relevance to any possible criminal offense. But our Enterprises Incorporated stated that relevance was not the only basis on which a subpoena could be quashed. The court confined its assessment in that case to relevance and did not purport to set forth considerations necessary to evaluate the broader question of reasonableness. Quote from Justice Stevens, quote, the court's opinion should not be read to suggest that the differential relevance standard of the court has formulated will govern decision in every case, no matter how intrusive or burdensome the request. There's more to be considered, is what they're saying. The DOJ argues that the expired statute of limitations on crimes does not mean that the court should quash the subpoena. DOJ contends that, quote, any subsequent criminal acts or acts in furtherance of a criminal conspiracy would restart the limitations period. In the DOJ's view, the possibility of criminal obstruction creates a timely offense. So they're saying, and I remember this from some of their filings, they're saying that we believe there's obstruction here and there's failure to preserve the records. And because those exist, that opens the door to charging further conduct that goes back beyond the statute of limitations, because those acts of obstruction and failure to preserve are connected to crimes that happened over 6 years ago. And so we can investigate those crimes that would on first glance be beyond the statute of limitations, because we're actually talking about a string of criminality they're all connected to each other. However, as Fulton County pointed out at the hearing and in its subsequent briefing, the case of Grunwald v. United States forecloses this argument. In Grunwald, 3 individuals were convicted of conspiracy to defraud the United States, which is a conceivable charge here in this case. That's one of the charges that we just went over that is non-capital, but it would be like beyond the statute of limitations. But if there's this big conspiracy involving multiple individuals, it's a different clock. So in theory, that would be ultimately the charge the DOJ would be wanting to bring from getting this information, should they develop enough evidence to bring one and get an indictment on it. It might be obstruction, violation that had to do with preservation of the election records, and then a conspiracy to defraud the United States. I'm going to toss these thumb drives that contain tabulated results out the window, because I think that they would harm the political interest that I have. On cert, the Supreme Court considered multiple issues in Grunwald, including whether the statute of limitations for conspiracy offense could be extended by evidence that the conspirators engaged in acts of concealment after the conspiracy's principal objective had already been accomplished. And I've said many times over the past years that acts in furtherance of the conspiracy reset the statute of limitations clock. And that's what this is saying here. The Supreme Court, that's not what it's saying, that's what it's referencing here. The Supreme Court held that acts of concealment undertaken after the central objectives of the conspiracy had been achieved do not by themselves extend the duration of the conspiracy for statute of limitations purposes. This is why the individuals who continue to lie about the Russiagate scandals aren't charged with some sort of conspiracy. The statute of limitations has run on it. And even though they continue to lie about their role, or at least misrepresent the whole story of Russiagate, it doesn't extend the statute of limitations. Any alleged criminal conspiracy to interfere with the results of the 2020 election was completed on December 14th, 2020, when Georgia electors met to cast their vote, or at the latest on January 7th, 2021, when Congress certified the results. Based on Grunwald, the DOJ cannot rely on alleged acts of concealment that any purported conspirators hypothetically engaged in after the principal objective, which would be the current president losing the 2020 election, would be the principal objective of a hypothetical conspiracy here, was achieved to indefinitely extend the statute of limitations. DOJ does not dispute that Grunwald is binding law and that it stands for the proposition that mere overt acts of concealment done after the central criminal purpose of the conspiracy have been attained do not extend the limitations period. Essentially, the DOJ attempts to contravene that opinion by arguing that, quote, Grunwald is inapposite because it is procedurally distinguishable. However, what the DOJ requests this court to recognize is essentially a limitless extension of the statute of limitations, such that a court is powerless to quash a subpoena despite the existence of Grunwald if the DOJ theorizes possible evidence supporting obstruction. They're weakening the Grunwald ruling, and they're what's the word I'm looking for? It almost makes statute of limitations meaningless. Yeah, it makes what the DOJ argued here is that the statute of limitations, if I can come up with some sort of theory about how these acts these people committed later on, very, very loosely tied, acts of concealment very, very loosely tied to the conspiracy we believe could be there, then we can always get a subpoena and we can always get a search warrant. The statute of limitations is just this. We can just bypass that by proposing some sort of theory of obstruction. As Fulton County states, under the DOJ's position that the mere possibility of an obstruction charge cures any statute of limitations problem, this court would be powerless to quash a subpoena in furtherance of a criminal investigation into any historical event, even if the event occurred many years or many decades earlier. Such a position is unreasonable. The DOJ cannot evade the statute of limitations based merely on a theory that someone, somewhere, somehow did something that was illegal. And we all know this. We all know this. And none of us would approve of a Democrat-run DOJ or presidency seeking to do this kind of thing to an abortion rights group, or any other such group that is typically associated with conservative values, right? We would be arguing the same thing. If this was a case that we just switch everything around, which is so useful to do, man, in these hyper political times. It is so useful to just invert things and switch the parties, switch the R and the D, and switch the political interest and talking points and see how much you like it. Really, I shouldn't say like it. That's one thing to examine, but also how reasonable it is. The DOJ also argues that any statute of limitations defense is not for this court to determine, but instead is an affirmative defense that must be brought by a criminal defendant after prosecution has already begun. Which I remember when I read that argument from DOJ, I kind of thought, that kind of makes sense. But now, after reading the judge's order, I'm like, actually, that doesn't make a lot of sense, and I don't think I really want a system that works like that. Because that could mean that you could get a bunch of information on someone and put together some theory and charge them based on information you never should have had. That should have been barred. While the court acknowledges the DOJ may be correct in stating when a party may bring up a statute of limitations defense, the DOJ's argument is also unreasonable in this discussion. The fact that the statute of limitations is an affirmative defense does not establish that the DOJ has any greater need for information related to unprosecutable crimes. it is inescapable that a defendant would bring up a statute of limitations bar. Indeed, it would be malpractice and constitute ineffective assistance of counsel for such party's attorney not to raise such defense. The DOJ essentially asked the court to turn a blind eye to the DOJ's investigation of non-specific allegations and/or crimes which have no possibility of conviction. In essence, the DOJ's argument is that it would be proper for a grand jury to investigate a time-barred crime, indict a defendant or defendants, and allow pretrial procedures to begin when the conclusion is inevitable. The statute of limitations on the relevant crimes has run. Therefore, the DOJ asked the court to use its already scarce judicial resources on what would be a dead-end prosecution. Oh, kind of like the Comey cases. The court is not convinced that it must ignore the clear existence of a time bar against any hypothetical crimes. 2, the government's proffered affidavit and subsequent briefing does not support an extension of the statute of limitations. All right. Second, the DOJ attempts to use an affidavit and subsequent briefing given to the court for in-camera review to support its contention that it has a high need for the subpoenaed information that overrides Fulton County's burden in compliance. However, even after the court reviewed the proffered affidavit and briefing, the court is not convinced that the DOJ possesses a strong need for the subpoenaed information. There is nothing in these materials that changes the court's analysis or conclusion. Footnote: DOJ filed a motion for in-camera review, which was granted by implication since the court reviewed these materials. Fulton County filed a response in opposition requesting access to both the affidavit and the DOJ's briefing. The court does not grant Fulton County's request given the court's conclusion that the information included in the DOJ's in-camera materials is not compelling. Oh. If the 11th Circuit on appeal disagrees with the court on this and remands this matter back to this court, the court likely would give Fulton County access to such documents for purpose of making a counter-argument to that of the DOJ. Interesting. Accordingly, Fulton County's request for access is terminated as moot. So that was still outstanding. So DOJ in camera means just the judge is looking at it. They don't want the other side to look at it. So DOJ let the judge or got the judge to look at the affidavit in the case that brought about the subpoenas. And they had a briefing on it. And the judge looked at it and said, yeah, this is not compelling. Not compelling. And he's saying if there's an appeal, then the court would likely let Fulton County also look at this non-compelling information as well. But since I'm already ruling on this and denying, and I'm granting Fulton County's ultimate request, I'm quashing the subpoenas, I'm terminating their request to look at the same material as moot. So they're not going to get to look at it. That is not good. That means this judge looked at the basis for them coming up with these subpoenas, which this grand jury in North Carolina was convinced, yeah, we need subpoenas for this, and approved them. Just like, yeah, I don't think there's a there. Now, maybe it's just because they're so broad. But, like with my example of the individual who threw out thumb drives, this fictional person committing that act, say you wanted to identify them among the volunteers and workers for the 2020 election. That affidavit and that briefing material would have to specifically say, okay, we know this person worked here or in this area. We know that there's a individual that here's a description of the individual. We have a witness who saw this occur or was told about it. It would have to be all this stuff that actually gave you probable cause here. All right. Finally, the DOJ attempts to articulate a reason to extend the statute of limitations from the Pitts case, the one over the 600 boxes. Specifically, the DOJ claimed that Judge Booley determined that the court could not ignore that a witness told an FBI special agent that some of the ballot images may have been modified as recently as January 11th, 2024, which is well within the statutory period. However, Judge Buley did not rely on these alleged wrongdoings to support his conclusion. Rather, Judge Buley stated that the description of the events in the Pitts case was troubling and that the government failed to explain that this modification date could have been caused by personnel from the Secretary of State's office simply renaming the file. In ruling for the DOJ, Judge Buley determined that it was not proven that the DOJ had callously disregarded the rights of Fulton County in seeking the search warrant for the election ballots. Nothing within Judge Buley's order convinces this court that the DOJ has a high need for the election workers' personal private information, which is something altogether different than the ballots. Additionally, even if the ballot images from the 2020 election were altered in January 2024, the relevant statute would be 52 U.S.C. 20701. That statute makes it a misdemeanor to modify records within 22 months of an election. Any modification of ballot images in January 2024 occurred long after the date that it became unlawful to alter records. So, even with the allegation from January 2024, it is still unclear how the subpoenaed information regarding 2020 would help the DOJ's investigation. Finally, and relatedly, it is not clear how poll workers from November 2020 would have anything to do with alleged alterations in January 2024. To the court, it seems that if the ballots were altered in 2024, that would be a crime, if it were a crime, independent of anything that happened in 2020. Therefore, Pitts certainly does not increase the DOJ's need for the subpoenaed information. Next part, and we're almost done. The subpoena places an undeniably high burden on Fulton County. As compared to DOJ's low need for subpoenaed information, the burden of compliance for Fulton County is severe. As stated, Fulton County is the most populous county in the state of Georgia. Undoubtedly, Fulton County depends on thousands of workers, volunteers, and other staff to run its elections. The subpoena requests disclosure of personal identifying information of thousands of employees and volunteers who participated in activities related to the 2020 election. Such a large disclosure of information threatens to chill participation in future elections, which will surely impact Fulton County. And I agree that it would have a chilling effect. I think if that was the only argument here for the subpoena against the subpoenas, I don't think the judge would quash it. But because the affidavit and the material presented there are so weak, statute of limitations has expired, and it's such a huge burden, I gotta agree with this judge's order. So he recounts all the information that would be requested and how that could make some election workers say, you know what, I don't really want to work in an election because something like this could happen. And again, this is another situation where you just switch the shoes, switch the R's and D's. Would you want to volunteer in Fulton County to work an election as paid or volunteered or as a contractor, right? Would you want to do that if you knew that if the Democrat won the White House, he could order his DOJ to get all of your information? And then they could conceivably come up with various theories of how you might have participated in some sort of crime? Let's see. In fact, at no point has the DOJ disputed that the subpoenaed information would chill the participation of poll workers. They didn't even get into that. And of course, we all remember Ruby Freeman and Shay Moss, and everything that went on with that. And I remember early on thinking they were involved in something. But as time has gone on, guys, it has not materialized. Evidence of them being involved in some serious criminal activity or any criminal activity has not surfaced. Allegations get floated around. People come up with various theories, but there's just no there. If there was a there, they would not have been able to successfully sue, because the evidence of them being involved in criminal activity would have been the ultimate defense to the lawsuit. So I think that they were what is called a red herring. I think the water leak, which has been completely misrepresented in media aimed at the right. Everybody on the right has been lied to about the water leak at the center where they were counting ballots. If you go back and look at the full video, the surveillance camera, and you watch the entire day, you find out that the way the story is told of that water leak is completely just flipped around, and it tells a story that's not true while using video. I remember Scott Adams used to say video lies, and video is so great, but there are times that video lies, and it lies when you show people video out of order and you change the context of the video, which is exactly what happened there. Anyway, is there a chance that questioning poll workers may yield some evidence? Maybe, but the disclosure of the requested information would cause substantial harm to Fulton County's interest in enlisting poll workers and other election volunteers in the future. Those who work to run elections, particularly those who volunteered in 2020 during the COVID-19 pandemic, should be valued and are necessary for successful elections in Fulton County going forward. Allowing the DOJ to obtain by subpoena the Fulton County volunteers and workers' personal information, given its inability to prosecute anyone due to the time lapse, would be unreasonable and place a heavy burden on Fulton County that cannot be ignored. In conclusion, denying this grand jury subpoena. The subpoena power of the grand jury is broad, but it is not absolute. If it were, the Supreme Court could simply say so, which it has not. Given the low need for the subpoenaed information and the highly burdensome nature of the disclosure of the same, the subpoena is unreasonable and must be quashed pursuant to Federal Criminal Procedure 17A2. So, there you have it, signed by William Ray. And recall that earlier he said in here that nothing prevents them from bringing another subpoena. Where is it at? Here we go. Nothing prevents a continued inquiry into these allegations by those who believe claims about what happened in Fulton County in 2020. Congress can get involved. DOJ can do investigations, but what they can't do is use a grand jury and all its powers to make these massive requests that are unlikely to lead anything viable. They can't go on fishing expeditions. And I hear in all these cases I cover and read, fishing expedition gets thrown out a lot with subpoenas and requests for documents and testimony and search warrants and all these things. Calling it a fishing expedition, I almost every case, it seems like, that comes up occasionally. Rarely does it actually fit. In this instance, it does fit. It does fit, and it fits because of the reasons detailed in that order. So I hope that adds some clarity to what's going on here. I know a lot of my people in my audience are not going to be happy that these Fulton County grand jury subpoenas were shut down. And there hasn't been anything here noticing that there is a appeal. There's been no filing saying we're appealing this judge's order. And I don't think there should be. I think what should happen here, not for him, Dan Bishop or Thomas Albus should impanel a grand jury in Georgia. And they should use a grand jury impaneled in the Northern District of Georgia to subpoena information from individuals or locations. They should do a narrow subpoena for information. If they really do believe that people who worked in the 2020 election, either as volunteers, contractors, whatever, have information or were involved in some sort of criminal activity, they should use a grand jury to get subpoenas for them, but have it very narrow. And they need a better basis than, or a more compelling basis for it than what they presented in this case. So, all right, that's where this one ends. Of course, we haven't heard anything from either Albus or Dan Bishop on this 2020 election probe and the 600 boxes that were seized. Tulsi Gabbard is now gone, and she didn't release anything that, you know, that informed of what happened with the raid. So they have 600 plus boxes of information to go through. It's going to take a long time. I would temper my expectations, folks. Definitely temper my expectations of what's going to come out of this 2020 election probe. So, all right, I'll see you on the next video. Thanks for watching.